like us to proceed now, regardless of the fact that some of the participants are still enjoying their coffee. As an activist of Documenta, the Center for Coping with the Past, I would like to tell you that this is an NGO that collects data and information in order to assist judiciaries and to assist victims in their reparation. I am extremely happy that we are here in Zagreb today. We were in Sarajevo several days ago and will go to Belgrade in a few days' time. After the conference in The Hague, we all knew how the legacy of ICTY is undisputable and unquestionable outside of the region, but under dispute within the region. The lack of trust is the result of a long-lasting, protracted smear campaign against the ICTY and its officials. Even hate speech of some sort, and it's also a consequence of how passive ICTY was with regard to reacting to such allegations. In that respect, I would like to extend a warm welcome to everybody here, and before I give the floor to panelists, I would like to tell you that on behalf of the civil society, as a member of civil society, we fight against denial of facts, and in favor of coping with the past. I think that we have not used the products, so to say, of ICTY as much as we should have, like evidence, findings, facts, and so on. But we are trying hard. We are doing our best and making progress to use these valuable and beneficial source of information so that we can state facts which Documenta holds dearly about the work of ICTY. I'm always happy to listen to representatives of various authorities who come to these conferences and they are not prepared. However, among audience we have victims, their family members, and I always wonder why it is so. I would always think twice before sharing evidence with such representatives of the judiciary. I expected Ms. Dolmagic to tell us what we should do in specific cases. What does it mean to us that we have an indictment against Vasiljevic and yet he is at large? What has in fact been done? Specifically, concretely, has anything been done? What I have also expected from Ms. Dolmagic was to respond to the question regarding this horrible fact that we still do not have any valid final judgments regarding war crimes in Croatia. I also expected some answers regarding the following question. We are currently witnessing an inappropriate campaign which is directed at civilian victims of war and their families. They have pressed charges against the Republic of Croatia, but they lose before Croatian courts and they have to pay for legal fees. It's a situation which is unbearable and should be sorted out as soon as possible. I had some expectations regarding Ms. Slišković as well. She should have talked about a terrible situation in which civilian victims of war are in Croatia. For example, at this point in time, there is no single legal act that regulates the status of raped women in the Croatian war. And this is something which is a failure of the ICTY's legacy regarding women who were victims of war, raped women, because rape is a war crime, a crime against humanity, a form of torture, and a means of persecution and displacement. I think that it's crucial to do something about these victims. Nothing has been done so far, and these people have no legal status in Croatia. Well, I could go on and on like this, but I will not. Let me now stop and address the members of the panel. We have Mr. Petrov here, the chief of this Mr. Martin Petrov, the chief of the immediate office of the registrar of ICTY. I would like him to tell something to the victims, their families, representatives of the media. Tell us something about what the mechanism for international criminal tribunals is. The Security Council has, on the 22nd of December 2010, decided to install this mechanism, a mechanism for the former Yugoslavia countries and Rwanda, because after the courts finish their work, this new mechanism will be installed. It has its chief justice, it has a prosecutor. Tell us more about what it is, what its mandate is, and what it will contribute to. Will it contribute to what we all expect in this region? And this is to finally emphasize local judiciaries and local prosecutors.
Thank you very much, and good morning, everyone, or maybe good afternoon by now. I have the pleasure to address you today on the topic of the residual mechanism and dealing with the past beyond the ICTY. Of course, dealing with the past is a very complex, philosophical, and concept to which a judicial institution like the ICTY can certainly contribute, but there are many more mechanisms which need to be employed to actually achieve that dealing with the past. The ICTY, as we all know, has contributed to the process of dealing with the past by holding fair trials, by giving voice to the victims, rendering judgments, establishing facts about some of the crimes committed, and importantly, individualizing guilt. But the ICTY has always been meant to be a temporary institution. We all have known from the day on which it was established that one day it would close its doors. And that's why it had a limited mandate, as we heard this morning. It had the mandate to prosecute only the highest ranking military and political leaders. Most of the work in prosecuting those war crimes remains to be done. It will be done on the national level. In preparing for its closure, the tribunal has been working over the years with the national judiciaries of the countries of the former Yugoslavia, not only in assisting them to build their capacity, but also in making evidence collected by the ICTY available for national prosecutions. And it has also, as Judge Aegis mentioned this morning, there have been a number of peer-to-peer meetings between judges, ICTY judges, and local judges, prosecutors, and other officials, just to essentially transfer the knowledge acquired by the ICTY over the years to the national judiciaries. This process, of course, is now coming to an end. The ICTY will soon close its doors. This doesn't mean, however, that the national judiciaries, national prosecutors, will be left on their own. The Security Council has established a mechanism that will be there to continue part of the work of the ICTY and to assist national jurisdictions in prosecuting war crimes. What is the residual mechanism? As you mentioned, again, the Security Council has established a mechanism in December 2010, which will be the legal successor of the ICTY and the ICTR, the Tribunal for Rwanda. It will be one institution, but it will have two branches, one based in The Hague for the ICTY work, and one based in Arusha for the work stemming from trials held by the ICTR. In terms of its structure, it will look very much like the ICTY. It will have one prosecutor, one president, and one registrar, which will be common to the two branches. And the president of the mechanism is Judge Meron, the president of the ICTY. The prosecutor of the mechanism is Prosecutor Jallo, who is also prosecutor of the ICTR. And the registrar of the mechanism is Registrar Hawking, who is also registrar of the ICTY. So while the mechanism will carry out some of the basic, essential functions of the ICTY, it will not have the full extent of the mandate of the ICTY. That's very important to realize. The reason why we have a mechanism in place is because there are a number of residual functions that need to be carried out after the tribunal closes its doors. But the mechanism will not have the authority to issue new indictments, for example. We cannot expect the mechanism to be carrying out new investigations and to continue that part of the work of the tribunal. Like the tribunal, or the tribunals, the mechanism is also going to be a temporary institution. Its mandate will be reviewed next in 2016 and every 2 years after that. So it will remain in existence for as long as the Security Council decides that there is a need for that mechanism. Another very important point to realize is that the mechanism will start, or rather has started, operations while the two tribunals are still in existence. And here are the two dates that I will mention because they're really crucial. For the ICTR work, the crucial date was the 1st of July 2012. This is when the mechanism opened in Arusha. And for the ICTY, that date is the 1st of July 2013. As of the 1st of July 2013, the mechanism, and not the ICTY anymore, will have jurisdiction for a number of functions. This change is very important to be understood well, because the two institutions will coexist for a period of time. The ICTY will be able to complete all of the proceedings that will be ongoing before it as of the 1st of July 2012. In other words, all the trials and appeals which are pending before the tribunal at the moment will be finished by the ICTY. But any new proceedings following that date, the 1st of July 2013, will be carried out by the mechanism. So in terms of purely judicial work, I'm talking about trials, for example, trials of fugitives. Of course, at the ICTY, we no longer have any fugitives, so that function is not that relevant to the ICTY branch of the mechanism. Appeals against ICTY judgments, for which the notice of appeal has been filed after the 1st of July 2013, will also go to the mechanism. The same goes for contempt of court proceedings, review of final judgments, and referral of cases. Any of these actions that take place after the 1st of July 2013 will be done by the mechanism. The mechanism will have the sole jurisdiction to be dealing with these matters. Having said that, these are the, if I can put it that way, the purely judicial functions of the mechanism. There are a number of other functions which will be probably most relevant to the countries of the former Yugoslavia, which will remain and the mechanism will be performing these functions for as long as it exists. They include the supervision of the enforcement of sentences. As you know, the tribunals, and in particular the ICTY, has agreements for the enforcement of sentences with a number of countries in Europe. The president of the tribunal, and in the future the president of the mechanism, has the authority to supervise those sentences. As of the 1st of July 2013, any request for early release, for example, will be submitted to the president of the mechanism and not to the ICTY anymore. The same goes for the designation of new enforcement states. Any future sentences that are rendered by the ICTY or by the mechanism after the 1st of July 2013, the president of the mechanism will be the one to designate the enforcement state. Protection of witnesses is another very important function that passes to the mechanism on the 1st of July 2013. In all completed cases, cases which are no longer pending before the ICTY, it will be the mechanism who will have the authority and the responsibility to protect witnesses and victims to the extent that they have the status of a witness in ICTY proceedings. The same goes for requests to vary or rescind protective measures. Any such requests that are submitted to the mechanism after the 1st of July 2013 will be dealt with by the mechanism. This is very relevant to what was discussed this morning, the admission of ICTY evidence in local proceedings here. Assistance to national jurisdictions is another function specifically identified by the Security Council. That includes the provision of ICTY materials, documents, evidence to national jurisdictions. As was discussed this morning, such requests are currently being submitted to the ICTY. In the future, it's going to be the mechanism that will be dealing with such requests. And finally, very importantly, the management of the ICTY archives. That function has the function of managing the tribunal's archives, so that's the archives of the two tribunals, has actually already passed on to the mechanism on the 1st of July 2012 when the Arusha branch opened. However, as far as the ICTY documents are concerned, responsibility for handling those documents will pass on to the mechanism on the 1st of July 2013. That means that the mechanism will have the responsibility to preserve, organize, maintain these archives, but also to manage them, to provide access to them, and to be coordinating the work with the information centers that the tribunal is now working on establishing in cooperation with the governments of the former Yugoslavia. So, what does it mean in practice? In practice, this means that as of that date that I mentioned a few times, 1st of July 2013, most of the functions currently performed by the ICTY will pass on to the mechanism. And the mechanism will be your main point of contact for any and all of those requests. The ICTY will remain in place and it will retain jurisdiction over ongoing proceedings, but most of its functions will actually transfer to the mechanism. Just to sum up, the mechanism that has been established will provide an institutional platform for the continuation of the work that has been started by the ICTY, specifically in the field of assisting national jurisdictions to prosecute war crimes. The platform will be there. It is up to the national jurisdictions, actually national prosecutors, to make use of it and to have access to that, the jurisprudence and evidence gathered by the ICTY. Of course, this only concerns the judicial side of dealing with the past, and as I mentioned in the beginning, it's a much more complex concept, and I'm sure that we'll hear about it from other panelists today. Thank you.
Let's move on. This conference today is organized by a program of the ICTY, which was launched by Gabrielle MacDonald, because she saw that after the first judgment was pronounced against Duško Tadić, one of the most notorious guards in the Omarska camp, where there were more than 5,000 Bosniaks kept and about 1,300 of them were held, she was appalled that after this first judgment, nobody from that area of Bosnia and Herzegovina knew that this judgment had been pronounced. And that's why this program was started back then. And I'm saying this to introduce Mr. Refik Hodzic, who was part of this program, and he was also part of the Information Sharing Center in Bosnia and Herzegovina, and now you're the director for the Center for Transitional Justice. Since Ms. Petrov has told us something about a mechanism that will be starting taking over some responsibilities as of the 1st of July, we are now faced with the fact that what is still ahead of us is something completely new. So we expect the national justice to do much more. So if you could say something about the context of the mechanism, and if you could please give us the background of the ICTY, its legacy, and the responsibilities of local justice system, and all of us who are part of that. Thank you, Eugen, and hello, everyone. You used one word, which is a key word, when discussing not only today and this topic, but it is key in the broader terms. And I think that the word context is a key to talk about any purpose of our talks. When I listened to sessions as the first session was very technical, and it seems to me that all of this is happening someplace else, far away from the reality we live in, and far away from where these processes take place. It seems to me that the first session was focused on the tribunal and the narrow context. That's why I'd like to talk about the broader context. And I was told that I have to be brief in order to make it to lunch on time. When we talk about context, talking about context is useful to have any good conclusions about this meeting. Somebody said during the first session that the ICTY is not the last court of that type. There will probably be other tribunals that will deal with crimes in a similar way. And that's why we should start from that. The ICTY is the first war crime tribunal after World War II. It's the first ad hoc tribunal, which we will no longer probably have. The context in which we live today in the international plan is that we have International Criminal Court, and between that court and the national courts, there will be some tensions on where some cases is going to be prosecuted. And ad hoc tribunals are something which is at the outset of the ad hoc tribunals period. It's important to understand that to be able to talk about other issues more specifically. But let's talk about the context. This session is dedicated to the way what we can do with the legacy of the ICTY. So to see what can be done with what's been collected, what's been done in order to face the past. I think that one of huge problems that we're facing is the use of phrases which have become lacking in meaning, and facing with past is one of such phrases. What are we talking about here today? We are talking about changes in the society which should happen, and mechanisms as the one we've talked about should be responsible for the worst possible crimes known to mankind: genocide, crime against humanity. These are the most serious crimes we can commit. If we limit ourselves to what was said this morning in terms of how many cases were tried, how many years it took, What were the sentences like? Why were people acquitted? Why this article of law is used and not? If this is the talk that we will be having about the ICTY, then we definitely need to ask ourselves whether all of it had its purpose. Those who were setting up the tribunal, nor us, who had great expectations, we never thought it would have anything to do only with the 161 persons. There was an expectation that this tribunal, with its work, will contribute to changes in the society that we want to see. But just to be clear, when I talk about changes in the society, I'm talking about changing values from a point where it's okay to kill a neighbor, to rape their daughter, to burn everything and expel them. We need to come to a point where this is unheard of and unthinkable. We need to know that there are institutions that will be there as protectors of our rights. Institutions which will not allow for something like that to happen, regardless of what our name is, of what our ethnicity is, religion, or political affiliation. We know very well that at some point we lived in a set of values where it was completely acceptable to go to your neighbor's house and do something. Not only were you not punished, but you were celebrated as a hero because you did such crimes, just to make things understood. So if we have a tribunal, as we were able to hear today, Mr. Agius put it nicely, we've reached the end. But now it's up to you to take this work forward. Ms. Goracic also talked about that. She agreed with that. And that's a fact. And to be honest, let's all agree that all courts in Croatia and Bosnia-Herzegovina and in the broader region should deal, if they dealt only with crimes in the 90s, they wouldn't be able to prosecute all the crimes, especially if you take into account the number of perpetrators. They wouldn't be able to do it in 80 years. So let's agree that not everybody will be punished. Never. So you will not have a point where everybody's punished. So now we have to ask ourselves, how can there be expectations, and why there are expectations that the tribunal, as one court, is able to punish everyone? How can that be? How can it be that people are misled about the work of the ICTY, that the ICTY is set up to write the history? Why, at some point, we were willing to believe that the tribunal is the conspiracy mechanism of Western countries to put in question the freedom fight of this or other nation? How can it be that we didn't see the tribunal as an institution which can contribute to us facing the facts, to us facing the demolition of values in this long and painstaking process to change the set of values? We have to take into account that the tribunal has indicted or convicted some people that we would never be able to prosecute ourselves. If we take all of these things, if we put all of that into context, and the values we live in today, and I'll try to finish now because I know that I've overstepped my time a bit. Let's see which reality we live in. We live in a reality where the impact of these proceedings, which are of extreme importance, of invaluable importance, the impact was limited by the discourse which was used in our countries that Eugen talked about by quoting Mirko Klarin. So instead of us talking about the substance and the evidence which were presented in court, instead of us talking about the causes of crimes, instead of us talking about those who gave orders, instead of us talking about consequences, And instead of us dealing with the consequences, we talked about what the accused person had for lunch in a detention unit. We discussed about whether somebody painted a painting in the detention unit or not, whether women from the did something, or the interpreters did this or that. So the discourse about the tribunal, I'm of course now going to extremes and giving you simple examples, but that discourse was present in the media. And it was always in line with the political vision which was used to view at the ICTY, and the substance was blurred. The media, brave people from civil society organizations, journalists, reporters, who tried to inform us about the substance so that we can have a look at it and talk about it. Not only were they target of political attacks, but also they were physically attacked. A very nice friend of mine, Drago Heldel, is a living example of something like that, and he could talk a lot about this topic. So if we talk about a reality in which the tribunal, the ICTY, worked, and what the benefit of ICTY to us should be, then we just have to briefly think about in what way such trials can contribute to a society. There is, of course, a huge range of topics that we could mention and what the benefits of these trials could be. But there are three basic things, in my view, that we should consider now that ICTY is coming to its end. Everybody talked about how precious the archives are, the documents are. I would probably not know 1/10 of what happened to me if it hasn't been for the tribunal's work. So this is really precious and invaluable. In my view, there are three things that should be beneficial. Punishing the perpetrators. The message to the society is that perpetrating the crime is punishable. And values which gave birth to crimes, which justified crimes and tried to cover up crimes, are no longer acceptable in our society. That's the message of punishing the perpetrators. You cannot bring down this message only to the number of years of conviction. Of course, that's important. How many years somebody got as a conviction is important because of the message I mentioned. Because if you give 2 years to someone for crimes against humanity, what sort of a message is that? The message could be, okay, if you're willing to spend 2 years in prison for that sort of crime, then it can be worth your while. Of course, the punishment, the sentence, the verdict is important, but not more important than the message. The second one is the justice for victims. We mustn't look at victims as people who should beg, who should ask for justice for what has happened to them. Victims have rights according to Croatian laws, according to international conventions which are part of the legislation of all of our countries of former Yugoslavia. Victims have rights. They are entitled to justice and truth, and they are entitled to compensation. And now that I hear that victims are losing cases in court, civil cases, it's a very interesting thing which should be explored further. Why? Because war crime trials give the victims an additional contribution in their final reconciliation with other parts of the society. Because the whole point of trials, the whole point of mechanisms is to stop the situation where victims are victims. Victims should become citizens equal to all of us. And they can't be equal to us if their child was murdered and they don't know who did it. They don't know where the child is buried or where the perpetrator is. Let alone when you have cases that through trials, you confirm they suffer, because sometimes other people say that it didn't happen. So if we talk about what the purpose of the trials in the context of justice for victims is, and the judgment is something that gives the right to victims that in civil proceedings or at the level of the country to be compensated so that their suffering can end. And their suffering is addressed in the best way. They can be provided psychological treatment because they are still suffering continuously, as is the case with the large majority. It can be financial compensation, it can be symbolic compensation, it can be any of this. And the third thing for which I think is the greatest benefit of the ICTY's trials in order to finish with the process of transforming the society, or at least start, is by identifying facts within the processes. These are trials which took into account the highest standards. You know what beyond reasonable doubt means. You know what the standard of such trials is, because beyond reasonable doubt means that you cannot try someone or convict someone without good, solid facts. What we can do is to take these judgments and to initiate a public debate on what has happened. The public debate, the dialogue, is a precondition for a change in society. The public debate didn't happen here, it didn't happen in Bosnia and Herzegovina, it didn't happen in Serbia. If you look at the societies separately, which is a mistake in my view, because if we only see to what people say, for example, Veljko Kadijević is a person who still lives in Serbia. The Croatian justice system, in Russia, sorry, my mistake. That's Serbia. Sorry. I don't want to be non-diplomatic, but what I'm trying to say is that it needs to be said that a huge majority of the Serb population which lived in Croatia no longer live here after the war, including victims or perpetrators of some offences. We have to talk about the role of Croatia in the war of Bosnia and Herzegovina and so on. We cannot take isolated looks on the societies. It won't get us far. That's why the initiatives such as RECOM are extremely important. What they're trying to do is to apply a historical perspective, a regional perspective. What I'm trying to say is that the trials have this potential to help us finally start talking on the basis of facts, not on the basis of our political views. At the end, judgments of the ICTY in an ideal scenario should in some way be referred to in the school curricula. In that way, our children could be taught something about the basic facts and events that happened. That's something that will help them in not doing something like that again. It will help them not repeat. I'm not being melodramatic. I will finish by saying there is the World Bank Development Report, which is the most distinguished, the most valued document about conflicts at the global level. Last year, this report very precisely said that in the societies where fundamental causes of violence and crimes are not addressed, in these societies there is no way to achieve development in the long run, to achieve security in the long run. There is 97% chance that conflicts will arise again. So sooner or later, and that's something we should think about when we're discussing on what we can take from the ICT's legacy. Thank you. Thank you, Refik.
I think it is very important to now emphasize one thing. We are considering this new fact of the residual mechanism that will continue the work of ICTY as of July next year. So there is that novelty to consider, the existence of mechanism, but also the work of national courts and prosecutors, and the pressure of the international community. What our countries did so far was provide evidence or arrest fugitives, and that was more or less the only form of cooperating with the ICTY. I think that this was done widely in the region exactly in order to avoid something Rafik mentioned, and this is to use other mechanisms to support the rule of law. I hope that in the continuation of this discussion, we will be able to address some more positive aspects of Croatian judiciary, because there are aspects we are proud of. We are joined by a lady who is an elect court for the ECHR professor at the Faculty of Law, Professor Turkovic. Could you please help us out a bit with this discussion? Could you please perhaps address this idea of ownership of justice, which will return into the hands of national courts and judiciaries, and they will have to take full responsibility for everything. This morning we were left with some unresolved expectations, and we're not sure how that will continue. So could you share your expertise? Thank you very much. Unfortunately, I was not able to join you this morning, so I don't know what was said. I would, however, like to share some of my observations, and I will make them brief. In one part of our society, the war is still going on. This is the exact reason why we have to talk about this. I will not talk about the legacy of ICTY, because this is what we talked about in the first session. But still, if we consider its legacy, we have to take into consideration two aspects. The first aspect is the expectations of ICTY, who initially were huge in all of the countries of former Yugoslavia. After a while, we had to face facts, and we had to deal with disappointment, because ICTY was shown to be something that left certain things to be desired. And then this clash between great expectations and then disappointment with reality. And I remember that I had huge expectations. One of our great expectations was that once the ICTY is established, the war would stop. It didn't. And then one of our expectations was that it would state the facts about the history of this conflict, and it didn't immediately. It was an important mechanism, however. It was. At the time it was established, our national courts were not able to deal with these cases in the way it should have been done. And ICTY has paved the way and shown the course to take. This was the first court that was established in that way after the Second World War. When you take a look at its history, the way it was established, the way it started working, the way it did some wondering and did not know certain things about how to go about procedural or process law and so on, it did, however, improve all of it, and it did play a huge role. It played a huge role in processing crime, but not only that. It played a huge role because it had a huge impact on international crime law, international trying, and international trials of war crimes. The subject of our discussion today is how to deal with the past. It is a motto. For some people, it is void of meaning, but it is important nevertheless. For some people, it's extremely important. ICTY and local courts are just one of minor mechanisms to do that. What they can do is to process crimes. That is extremely important. But what is it that they can give to victims? They can give a sense of satisfaction. But what research shows is that what victims get at the emotional level from courts and trials is dissatisfactory. So to limit ourselves in expecting courts to make us face facts is too much. So how do we make courts do more for victims? How do we give victims a new and greater role in trials? I think that ICTY was the one who increased that role. ICTY made progress even after the Nuremberg trial. ICTY did even more because victims were given a special role in criminal proceedings. I think this will be a difficulty in national courts in Croatia. Why? Because it will mean that we have to change our national legal framework with regard to criminal trials. We will have our penal code amended and the legal framework amended on the whole. This function should be introduced, but it will still, and it is still, insufficient. We have included victims, we have made certain mechanisms available. But the moment where we have to get the victim involved, included into the trial, is still not satisfactory. If we saw victims given all the rights and entitlements they have at ICTY, it would be sufficient. You mean the reparation fund? No, no, no. I mean the participation. What kinds of rights to participation victims have in trials? How much they're able to say, how much they're allowed to say, and what they're allowed to say. I know that it can't be just free speech for all victims to say whatever they like. I know that criminal trials have to try and limit that a bit because we are there to state facts and to see whether somebody is guilty or not of a certain crime. And we have to accept the fact that we will not be able to prosecute everybody. However, we need our society to show that it is ready and willing to reject some of its past, that it is ready to prosecute war crime and war criminals, and it doesn't have to mean that we have to convict everybody in order to yield the preventing, deterring effect of such convictions. You can never convict them all. But what it is important is for a victim to be given the opportunity to participate. And not even then will they achieve everything they want, the victims. So we have to have formal proceedings and we have to try and restore justice. It's only partially possible, as it always is. But there is something that this society lacks even more. I think that we are even more willing to start prosecuting crimes. Then we're willing to face the past with respect to some other elements, like, for example, facing these situations, what happened, what the truth was. Not many people talk about that, and a small number of people know what happened. Victims have this need to talk about what they went through. They want their suffering to be recognized. What they also want is for the perpetrator of the crime to perceive what kind of an impact they had on the victim's life. This is something that brings more satisfaction to victims than convictions, than judgments. As regards compensation, reparation, of course we can do that through trials, but we have significant problems regarding that in the Croatian judiciary. If Croatia wanted to do right by itself, it would have to do much more. I know that even Germany and Canada and Aboriginal issues had problems. However, Croatia should work on establishing a foundation that would serve the purpose of compensating the victims, so that we don't have victims who have to go through trials again. Such a foundation would enable the state to take the matters into their own hands and make their victims equal citizens, citizens that no longer feel hurt. I know that there are some other mechanisms, of course. You mentioned training, awareness raising. That is important. What we should do, in fact, is to try and review our history books. We should take a look at what it is our children learn at school. I have a child who is in a sixth grade elementary school. He's 11 or 12. And I read the book with my son, the book that was given to my son to read. It seemed to me that it was horrific because it is impossible to not take the right attitude, because the question is what is right or wrong, but any attitude, because he is that young. To read such a book at such young an age could have severe psychological effects, because it's the war, it's this historical legacy we're left with. So we did a lot, and we made this cardboard board poster where we wanted to explain what the book was about, but it was difficult, and I don't know how many other people did that. So it is difficult to learn about these things, to teach about these things. But there is a joint project, for example, between Bosnia and Herzegovina, Serbia and Croatia. This joint project has to do with the vertical level of education and training and the entire education system. It has to do with humanitarian law that needs to be introduced at all levels to educate children and students about what happened in the territory of former Yugoslavia and how we assess that, and also something about human rights and so on. So I hope that something along these lines will be done in the future. I have said several things about what I think is important regarding the issue of how ready our judiciary is for all this. We have to believe we're ready, and I don't think that we will give our trust in vain. There is something interesting that I would like to share with you. There is something interesting about this whole region. It's almost a region that serves the purpose of experimenting with what kind of judiciary is more effective and efficient. For example, we've got Croatia, regular courts, regular full-time judges with their education and so on. Bosnia and Herzegovina, a different system. A mixed system of different judges coming from all over and so on. Kosovo, again. Serbia, a special court, a different story all over again. It's almost an experiment unfolding before our eyes, where we can see different approaches to the same issues in a community which is actually similar in their heritage, historical heritage, and legal heritage. So we will be able to see and assess what kind of a system is proven to be better in tackling these issues. Regarding the international community, I think they have done so much through ICTY for us. Through the ICTY, they've developed certain procedures. These procedures should at least be attempted to be introduced into our system. When our courts try these cases, it's difficult to do it properly without reading ICTY's documents. So there's an issue for you. How do we force our judges to read ICTY documents, judgments, rationales, and jurisprudence on the whole? there are some specific issues regarding international criminal law, and this is also something that we have to learn about through reading about these judgments. So this aspect is also very important to read and then interpret and transpose these judgments and procedures into our system. Criminal procedures are not sufficient, as I've said. We have to talk about everything else, about all other aspects as well, if we want to, as soon as possible, achieve every single aspect of what facing the past really means. And this is first and foremost reconciliation. As regard single uniform truth, it's difficult to come to that. It's difficult to accept it. We all come from different perspectives and we all have our little truths about what in fact happened. I used to live in the United States of America. I had a son and I was driving him back home from school and he told me, "Look, Mom, we talked about the Civil War in the United States of America today," which of course took place a long, long time ago. And you see, Mum, we can never have a single story about a civil war or a war of any kind. And he was so young, and I asked him, "How do you know that?" "Well, we looked a film today, two films in fact. One taken by a southerner and one by a northerner. And these are two completely different stories about the same war." So what I'm saying is that it's not perhaps a horrible thing to have two different stories. It's horrible not to be able to live with these two differing stories. Of course, we need to not have two divergent stories totally. We need to bring them closer together, but we cannot always expect them to be completely the same. Thank you. Thank you. We've got Mladen Stojanovic with us today as well, and he will talk about the Documenta, Osijek NGO, and the Civil Center for Peace, Non-Violence and Human Rights from Osijek. Mr. Stojanovic, we said that facing or dealing with the past for some people is a phrase void of all meaning. What does this mean regarding the legacy of ICTY and our institutions? How much is done? Perhaps not enough. Could you pick up on what we heard today? And could you talk about the command responsibility? Because ICTY was the one who distinguishes between command responsibilities and other types of responsibilities, such as individual. It also did not want to allow for impunity. We have mentioned some pressures that we exerted in order for the Statute Application Act to be amended, and many other things. So, Mladen, could you take us through your perspective on these issues? Because you publish several reports every year about what takes place in the Hague courtrooms.
First of all, many things have been said during the first panel and during this panel. I'd like to apologize in advance if some things get repeated. Considering the fact that I was invited here on behalf of the monitoring team which monitors trials for war crimes, I'd like to share with you some situations that Eugen has mentioned during the introduction. A lot has already been said about which cases were transferred to the national level and national courts by the prosecutor's office of the ICTY. First, we have to separate between two different types of cases. We have cases where the prosecution of the ICTY has issued indictments and then transferred them to the local judiciary. And then we have the category 2 or 3 cases in which either investigations were carried out and no indictments were issued, or some investigations were under course but were not finished. With regards to the cases which were transferred to national courts where there already is an indictment by the ICTY, I would like to point out that there are about 8 cases which include 13 indictees. Most of these cases were transferred to Bosnia and Herzegovina. In Croatia and Serbia, there is only 1 case, respectively. The Ademi Norac case was transferred to Croatia, as you probably know. Why was this case important? This case is important because of the fact that the transfer of the case and the adjustment of the indictment to the Croatian legal system has encouraged this practice of indicting commanders who did not prevent crimes among their subordinates. During the time where these crimes were perpetrated, there was no special provision which would regulate command responsibility. And there was a question whether commanders in Croatia can be indicted and convicted because they did not do anything to prevent their subordinates from committing crimes, although they knew that crimes were being committed. Through that, they accepted crimes and aided and abetted these crimes. There were some discussions whether something like that was possible or not. Some lawyers even today think that it's not possible, but the case was transferred to the Croatian judiciary. There was 1 acquittal and 1 conviction. As I've already said, this has encouraged a practice in the Croatian judiciary and in the Croatian legal system which was good. After that, several other indictments were issued. The cases are still underway. For the time being, it's difficult to say to what extent every individual case is successful or not. With regard to why this is important, I have to point out that in Croatia we still have a huge number of unprosecuted crimes. Most of these crimes are unprosecuted because you have an unknown perpetrator. However, very often it's possible to identify which part of the army these people belonged to. Because if we know what the core was, or what part of the Croatian army it was, you can then reach and find out who commanders were. The Ademi Norac case, for example, is important because in Croatia it did open that opportunity. Of course, I don't think that something like that would happen without the case having been transferred to Croatia. So I don't have any illusions there. It wouldn't happen. But if we compare the situation of what I talked about, of course, I'm only talking about Croatia. You have to know that. With regard to Serbia, I talked to some Croatian prosecutors who are in touch with Serbian prosecutors. Serbian prosecutors don't think that commanders can be prosecuted in Serbia. That's why in Serbia we don't have any indictments against officers, higher-ranking officers of the Yugoslav National Army. Within civil society organizations, we believe that debates and discussions should be encouraged, views should be exchanged, so that the practices could become coherent and sustainable, even if you're working with different legal systems. You have different legal systems of different countries, although our systems were identical before 1990. So these are only interpretations. And from the human side, the willingness to prosecute crimes is also important. When we talk about the transfer of cases, apart from the Ademinorat's case, which was one case which was transferred to Croatia after the indictment was issued, you can also transfer cases where there is no indictment, but some investigations or part of the investigations were carried out. A couple of years ago, when we were monitoring one case, which Vesna Teršelić has briefly mentioned, this was the case for a crime committed in Marino Selo, close to Pakrac. There was a question back then whether testimonies and depositions taken by ICTY can be used in that particular case. The Supreme Court decided that in that particular case, such statements cannot be used. The Supreme Court treated them as police statement. They were not admitted as admissible evidence. And the Supreme Court made such a decision after interpreting the Article 28 of our laws, which was quite imprecise, and it did enable them to interpret that provision in such a way. Those of us who monitor trials reacted immediately. We said that something like that can be changed. Just to compare, I'd like to tell you that the same statements were used in the Ademinorat's case because the indictment was issued in The Hague and then the case was transferred to Croatia. But in other cases, for example, the Marino Selo case, evidence which were taken which were collected by the same bodies that collected evidence in the Ademinorat's case were not admissible because it was done because there was no indictment from the ICTY. Ms. Garacic and Ms. Dolmagic and Vesna Teršelić during the first panel talked about the fact that there was an amendment to the law in 2011 and that such personal statements and testimonies can be used, regardless of the stage when they were transferred to Croatia. However, the situation in reality does not correspond to that. The Marino Selo case was retried, and even after the amendments, these testimonies, personal testimonies, were not used as evidence. They were not used because the decision of the county court and the Supreme Court was such that it treated such evidence as something that can be used only if the case started after the amendments were adopted. That was their interpretation. And generally speaking, when we talk about the mechanism which will be operational after the completion of the ICTY's work, its basic assistance will be the assistance to national judiciaries, because the mechanism will respond to letters rogatory or requests for assistance on the transfer of evidence. But the responsibility for prosecuting crimes is on national bodies. And the responsibility lies even on local politicians. Somebody today, during the day, has said that in this part of the world, in all of the countries which were created after former Yugoslavia, is an area which needs continuous political willingness to prosecute war crimes. But there is no such political willingness. Miss Zlata Đurđević, the professor from the law faculty, talked a lot about the Null and Void Act. We don't need null and void acts. We need better regional cooperation. We need contracts, agreements between governments which will regulate such cases. However, there is neither willingness nor the same views that there should be some level of consensus between our governments. At the beginning of the year, the presidents Josipovic and Tadic had a common initiative, but then the power changed in Serbia. In Bosnia and Herzegovina, it's impossible to reach a compromise because Bosnia and Herzegovina believes that everybody should be tried where the crimes were perpetrated. On the other hand, you have Serbia and Croatia who want to try the perpetrators on the basis of their domicile or habitual residence. Judge Garacic said something about the current number of cases and the current number of indictees before county courts. She said that there are 99 cases with 519 indictees. Apart from that, she very honestly said that most of these cases are inactive at this point. I would say that luckily we no longer apply this practice that we have a huge number of cases in absentia. And most cases are inactive because of that. In order to activate these cases, regional cooperation should be improved. Cases should be transferred to those countries where perpetrators actually are. Then, at that point, judicial bodies will have to decide whether to prosecute them or not. A huge number of cases hasn't been transferred. They haven't been transferred because these cases are, under quotation marks, not ready for transfer because investigations were carried out and indictments were issued during the 90s or at the beginning of the year 2000, and indictments very often are not corroborated by evidence. In some cases, criminal offenses for which indictees are indicted are not war crimes at all. The State Prosecutor's Office on several occasions reviewed all the indictments. However, there are still such cases. And that's what we come up with. That's something what we see in practice. Thank you.
Thank you, Mladen. We still have some time left, and I hope that we'll be able to do a brief discussion before lunch. But last but not least, we have Drago Hedl, a journalist. I would like to first share some perspectives with you. In Documenta, an NGO, we feel a bit provoked, not only regarding the judgment to Croatian generals from April the 15th, 2011, but also regarding the way in which the public in Croatia is informed about and facing the dark side of our history. We have been monitoring the information provided by the Croatian media from 15th of April to the 30th of April. Victims' voices have not been heard. Descriptions of their suffering has not been heard. No people were given a chance to talk about this, except the generals, friends, and people like that. The whole procedure that lasted a long time in ICTY was not considered through special television broadcasts with proper assessments. I don't know whether the Croatian public at large knows that Stanisic and Simatovic, former chiefs of the Serbian secret services, are indicted with ethnic cleansing of civilians. I don't know whether Croatian society knows that Perisic is indicted with not stopping the shelling of Zagreb. And it seems to me that those journalists who are there just do not do their job, and the international correspondents are horrified by the way in which Croatian media neglect to inform the Croatian public about this, or the way they do it when they do. So I hope that with the new team of people in charge of the Croatian public television, we will see a change in this tendency. Drago, could you please share your views? Thank you. We do not have much time, so I will try to reduce my speech as much as possible. I think that one of the most important things to mention regarding the legacy of ICTY is the next step after it, and that is the legacy of courts in the territory of former Yugoslavia. What will these courts leave behind them after having learned from the ICTY? We know that we now have a huge source of data and information. We have personal testimonies, evidence, and everything else that took place at ICTY, and we can now benefit from. There are the archives, of course, which the ICTY leaves as its legacy. There are also several other things to consider. First and foremost, we see already now that some people are attempting to revise what ICTY has already passed judgments on. Facts-wise, war crimes, genocide. We, of course, expected that. However, we cannot allow that to happen at the highest levels of highest-ranking politicians and courts, because we do know of instances where thousands of people were murdered, young men, old men, even boys. We cannot revise history. If such a crime, for example, the Srebrenica crime, is revised, minimized, and even completely denied, this is unacceptable. The legacy of ICTY will leave us with a lot of work that needs to be done by our courts. This needs to be done in order for us to learn the truth and to try and do some justice by the victims. We have heard by numerous panelists here today. I am a journalist by profession, so I wrote about numerous war crimes. I could go on and on stating examples about how all this hits victims. Victims sometimes get victimized twice, not only going through what happened to them, but also going through trials then. Because trials were carried out in a way that re-victimized or marginalized and neglected victims. They were even sometimes insulted and punished for the second time. Let me share one example with you. War crimes in Osijek trial, where victims all of a sudden became perpetrators and perpetrators heroes. What contributed to this happening was the media. the media kept talking about certain things that misled the Croatian public and made it completely incomprehensible, and they could not assess what happened. People don't even know what went on. There were not enough of attempts to explain to the public at large what happened in the so-called sellotape or garaža incidents. I think that the legacy of our national courts is important because there is one thing that their legacy will serve for, and this is a persistent will of some people to make crimes less relevant or even minimize what happened in the past. Such attempts will exist in 10 or 15 times, and the legacy of our courts should not allow that. We should use the legacy of regional courts in order to prevent all those who would like to revise history in doing that. Since we have to speed things up, let me share just one more case that corroborates what I have been saying. And this is that after the ICTY's legacy, we have to create a legacy of our national courts from the entire region. We recently had the unveiling of a monument dedicated to victims of war in Osijek. And this was also a monument to Homeland War defenders. There were names and surnames of victims written on this monument, of all those who lost their lives to war, be that in combat or as civilians, because you do know that in Osijek we had hundreds of people who lost their lives, and the exact number is still not known. So we have these names and surnames, but what it says is the victims of Grand Serbian aggression. Although we do not only have victims who are victims to Serbs, but also people who were murdered by Croatian people. And these names are there with such a title. So this is not a matter of ignorance. This is not a matter of speeding. This is a matter of an attempted revision of history, where crimes committed by Croats are ascribed to Serbs. And I think this is something that our common sense should prevent, because we're people who respect the rule of law. So, once again, I would like to reiterate that after ICTY's legacy, what we need is the legacy of national courts, who would also collect evidence and also provide us with documents about facts, so that nobody can make such attempts again. Thank you, Drago. As Nerma said, we will discuss until 1:30 and then we will take the lunch break. So, would anybody like to speak? Manda Patko. My name is Manda Patko. I come from Vukovar. I am the president of the Vukovar Mothers NGO. I did not speak so far, but I do agree with somebody who said that the war is not over yet for some people. Well, for some of us in Vukovar, we haven't found our dear ones, and we are still in 1991. Today, we see the date when my husband went missing. I still don't know where he is. It's been 21 years now. I don't know where he is. I don't know where his remains are. The gentleman here said that every country has the right, or at least should, compensate its victims? Well, I went to Serbia. I paid a visit to Belgrade. I went to an NGO. We talked about humanitarian law, and all of us who spent time in camps during the war were there. I went through the hands of Chetniks, and I was in a camp, and I wanted to speak some 5 or 6 years ago. I also wanted to speak before a court, but I have never learned whether what I said was admitted as evidence at court. What I'm trying to say here is that there are some youth initiatives, and they are important. For example, in Belgrade, there was a youth initiative that organized a conference 4 or 5 years ago. They condemn the war that took place in Croatia. They condemn the excessive shelling of Vukovar. And they told me that they submitted a case or a claim before the ICTY for excessive shelling of Vukovar. However, we also have some claims about concentration camps of Serbia. So I don't have information what happened there. Do you know that there are bilingual schools and bilingual nurseries in that territory? I mean, in 50 years' time, if we continue this way, the war will break out all over again. Why are these things happening? I have traveled through a lot of countries, and I know you probably have too. But if there is an official language of a certain country, then that's the language that people use at school. And if they want the trial of Hadžić, and you doubt that there will be any specific information that the court will find out that would help you. So, could you tell me what you expect and what has happened? And well, I would first like to extend condolences on this occasion of your husband's missing anniversary. Well, for some percentage of our population, the war still goes on, and I think it's a majority percentage. I think that the fact that we hear no guns around us does not mean that the war has ended for us. I can definitely state that with certainty regarding Bosnia and Herzegovina. And the war goes on mostly because of what politicians do. Somebody mentioned the denial of genocide. Somebody mentioned hate speech. Well, you should only listen to what the president or the spokesperson of the Republic of Serbia's president is saying to the media. I really don't know what happened to the youth initiative, what happened to all those claims made to the ICTY. I don't know what ICTY did regarding the concentration camps you mentioned and the one you were in. But what I do know is that when it comes to reparation and compensation that needs to be made to victims, as it was mentioned by colleagues before me, there is absolutely no doubt in my mind that victims should not be the ones to press charges and go through trials. I do, however, admit that we have to be aware of the situation we're in. We cannot expect the kind of foundation that Germany has had for compensating the victims of the Holocaust. We have seen some examples of reparation in Argentina and some other countries, and that reparation was not done through financial compensation. And victims' reparation doesn't have to be financial. It can be in the form of free education, free healthcare, priority in employment, and so on. All of these are ways in which your state can assist you and offer reparation to you as a victim of war. you only need to be aware of options, of possibilities of reparation. There is one thing I would like to share with you, and this is a thing I am deeply convinced in. The one fundamental single problem that we have with making progress in how we treat victims, how we are divided in our communities, for example, through bilingual schools. The single problem we have in our judiciaries and our practices is political will. The lack of political will is a much greater problem than all the aforementioned technical issues. Mr. Petrov, could you give us your perspective on this situation of victims, communication with victims? What will the residual mechanism do in that respect? Will it make communication with victims a priority?
I think that the residual mechanism will have the mandate to specifically communicate with victims, simply because, as I mentioned earlier, it is supposed to be a very small and temporary institution whose mandate is really limited. But to the extent that, as part of its mandate, the mechanism will have the authority and the possibility to communicate with the region, particularly in the context of national prosecutions, I think that there is probably some room for for that process to also include victims. An important element of the stage that comes after the closure of the ICTY, of course, is the information centers, which will be subject of the topic of a discussion later on today. And I presume that's probably a more appropriate place to discuss the communication between victims and the mechanism, essentially, that will stay behind after the ICTY closes its doors.
First of all, I'd like to confess, because 2 weeks ago I participated at an event and I have some experiences that I'd like to share with you. With regard to the previous panel and regard to the discussions that were taking place here, from the standpoint of a victim, I wouldn't say I was uncomfortable, but I can't understand some things. All of you who haven't been affected by war should understand that 20 years have passed after the war. And then you have the deputy state prosecutor who, after 20 years, says there is a lot of work ahead. We will do our best. We will try to do our best. Will we be alive by that time, after 20 more years? For example, I come from Slavonski Brod. It's a town which was shelled on a daily basis between March the 3rd to October 15th. That's a huge number of days. We were shelled on a daily basis with long-range artillery from the Bosnian side. The result of that are about 300 victims. 148 of them were killed, others were injured. And there is a very sad fact about that. In the town of Slavonski Brod, at that time, 28 children were killed. The youngest was 8 months old. Considering the fact that for the last 10 years in Slavonski Brod, we've organized meetings of families who lost their children. Every year also we asked for those who did it to be held accountable, because we want someone to be accountable and responsible. We want someone to be held responsible for killing the town, for killing the children. It's not enough to say, I'm sorry, I apologize, or we apologize. I apologize that your child has died. That's not enough. For 10 years, we asked and questioned the issue of responsibility. And this year, the town of Slavonski Brod supported us, and they supported our initiative. The result of that was that about 3 weeks ago, I can't remember exactly the date, I was invited by the court about cooperation between the court and the victims. I got an invitation from the court that I'm invited as a witness against Mr. Narancic. During the first 10 minutes, I was shocked. Who's Narancic? Who's that person? Who wants me there? Why am I a witness there? When the state prosecutor's office, how can they expect us, small people, to understand the terminology they're using? I didn't understand that. After that, I went online to see who Narancic is. And then I understood, because I didn't know what I was supposed to do. I'm trying to say that on the basis of our initiative, the investigation was launched. When I came to court, I found out something more. There is another devastating fact. The investigation was launched in 2005. For 7 years, it was somewhere, and it took them 7 years to ask me to testify what's happened to me and my family. It took them 7 years. I can't describe to you the way I feel now. The judge was completely unprepared. This is the county court judge. It seemed to me that he didn't know what to ask me. He had police investigations in front of him. There was a police document. Everything is there in the document. He has everything there. What happened, why it happened. And then I asked the judge who Narancic is. And he said the investigation was carried out against 3 persons. The other 2 were 2 commanders from the Yugoslav National Army, and they were stationed in Bosnia. 2 of them are no longer alive, and Narancic is now in Serbia. What I was also afraid of is that I personally don't have problems talking about it. I can talk about it a lot. I can scream about it, although nobody wanted to listen to us over the last 20 years. We were always shoved elsewhere by the government and by other countries not to be heard. And I'd like to say that there is no institution in the Republic of Croatia that you can call and ask them how many people were killed in the homeland war in Croatia. No institution. What is even more sad is that parents whose children got killed will be invited to testify. What about others who went through horrible things? So what I'm trying to say is that this is not a proper way to deal with these matters with regard to reparation. Even if all of those who perpetrated evil, even if they disappeared from the face of the earth, it would mean nothing to me. This is something that will not bring back lives to any of us. When you say reparation, you shouldn't only think about financial compensation. Thank you. Thank you, Juliana. We have the county state prosecutor from Osijek. Maybe he could respond. We have people from the Ministry of Justice also. What I'd like to say at this point is that this panel is now over. all of them who want to say something more can do that after lunch. We will continue after lunch at 2:30, and the lunch will be in the restaurant Kaptol on the right-hand side from the reception. Nerma Jelačić will be moderating the next panel, and Hrvoje Klasić, Zoran Pusić, Sven Miklić, and Bori Papavić will participate in the next panel.